today is about speaking the language of prosecutors, taking a case from investigation to verdict. This session will be presented by Mr. Ben David, who is the District Attorney, New Hanover and Pender Counties in North Carolina. Ladies and gentlemen, join me in welcoming Mr. Benjamin David.
And then you can stop share here.
You can take over, Mr. Benjamin.
Well, good morning, everyone, and good afternoon in the United Arab Emirates. My name is Ben David, and I am the District Attorney for New Hanover and Pender counties in North Carolina in the United States. I want to thank you for the kind invitation to speak today and particularly compliment the work of the Internal Auditors Association throughout its many global affiliates, and particularly our gracious hosts for this incredible opportunity to address you today. I know that as I'm talking to you, my words are being translated into other languages, and actually what I want to speak to you today about is how we can translate your language into mine. That is, to learn how to speak the language of prosecutors and take a case that you've worked so hard on, from investigation into the courthouse and ultimately to a verdict where you can get justice. Now, to do that, I'm going to take you on a journey, one that I've been on for over 2 decades now, as the district attorney in my hometown of Wilmington, North Carolina. This is that hometown. This is the mighty Cape Fear River that is to the west of my district. You can see the downtown Wilmington area in this picture. Mighty Atlantic Ocean is to the east, and there is great wealth here. There's over 300,000 people who I am privileged to represent. And you know, prosecutors everywhere, regardless of their hometown, all have the same job. We speak for the dead in murder trials. We give victims a voice at the courthouse. We are the conscience for our communities anytime a crime occurs. Now, maybe you've heard of my hometown and maybe you haven't. If you've watched Hollywood movies, many are filmed here, including most recently Iron Man 4. In fact, this bridge was in it. You've probably heard of our most famous resident who grew up here, learned to play a little bit of basketball on our streets. His name was Michael Jordan. He went off to the University of North Carolina at Chapel Hill, and then off to the Chicago Bulls, and the rest, as they say, is history. He, like so many people who live in our community, have great wealth, beach houses. We even have some beautiful islands. But with great wealth, as many of you know, come the opportunity for great victimization. And through the many years that I've been a prosecutor, I have met many people who have suffered great economic harm. I want to talk to you about their cases today. Now, 16 years ago, when I first ran for office, I was privileged to be elected to the district attorney's office and lead this incredible team that you see in this picture. There are 50 people in this office. We handle more than 5,000 felonies each year. Those are things like rape, murder, armed robbery, arson, drug trafficking, habitual felons, and of course, many of the cases we're going to be talking about today involving the economic harms that we see. On top of that, we have 20,000 misdemeanors. These are things like domestic violence, larcenies, shoplifting, driving while impaired. These are cases that involve some of the scams we see on computers and on the phones. And then there are, on top of that, 50,000 traffic offenses every year, the tickets that officers hand out. And you know, I advise over 1,200 police officers in 20 different police agencies. I'm in charge of calling for large-scale investigations that sometimes go into other jurisdictions. And I am in charge of making sure that we take these nearly 75,000 cases into a courtroom. Years ago, when I was a much younger man first running for office, I was told the first rule of politics is this: you cannot serve if you don't win that election. Well, to you who might be an auditor, someone who might be a crimes investigator involving financial theft, there's a rule for you that we need to remember as well. You cannot get justice if you don't get into that courtroom. And so in order to do that, you need to talk to someone like me, someone like in this picture, to make sure that your priorities become our priorities. And to do that, we need to speak the same language. We need to overcome that barrier. So let's talk about how we do that and first recognize the big challenges to bringing these cases. What are they? Well, obviously the first big challenge is that many victims do not want to report these cases. They might be vulnerable. They might be people who are either elderly, in the case of so many of the inter-family cases we see, or the scams on the internet, or more likely in your case, they're sophisticated clients, maybe bank presidents, people who are used to having it their way and have great professional reputations. And they do not want to acknowledge publicly that they might have fallen for one of the many financial crimes we can talk about. And with embarrassment and shame comes underreporting of these cases. The next big challenge that we face is these cases are often complex. They involve a lot of paperwork, a lot of math, and many people who practice law went to law school to avoid mathematics. And so they don't want to see these files, and they get scared when they meet with someone like you and say, this just looks like too much work. The third challenge that we often see is that many of these defendants don't even reside in our hometowns. They come in through the internet. They come through long distance communications, and they might be outside the territorial reach of us. And so there are challenges to even bringing them back, particularly if the amount that they've taken in our locations is less than the amount it would take to bring them back under what we call extradition. And so a lot of the worst defendants that are out there steal from different people around the globe and escape justice because they keep moving. And finally, what we see as a challenge is that prosecutors like me, we say that if everything is a priority, then nothing is a priority. And our first priority is keeping people safe and making sure that if they've been harmed, even killed, that we're going to go after those violent cases first. We're talking about prison time as tending to be prosecutors' priorities. And many of these violent cases that we talk about, of course, involve that. But many of the financial cases that you're going to bring to our offices, they might only involve probation and restitution. So talking the language of prosecutors means making us understand why this economic harm can be every bit as severe as the violent cases we see. And I'm not having a theoretical conversation with you. Take a look at this picture. You probably see a burned out house and think, well, maybe this was a person behind on rent or someone who wanted to get insurance money from a company they've paid to for years. Well, this is not insurance fraud. This, in fact, is murder. It's arson. This is the case that I'm currently trying right now, and I have been since March 1st. There were 2 women and 3 children in this home when the defendant poured gasoline all over the wheelchair ramp you see in this picture, and a woman who was not able to walk and a 14-year-old little girl who was blind and autistic perished in that fire. Now, that's obviously a case that has my full attention and is going to consume vast resources in my office while we're bringing one of those 5,000 cases to justice. So what do we do? What do we actually do to make your priorities our priorities and understand that this economic harm is something that we need to focus on? Well, there's a critical way that we analyze all cases, and that's called the FIRAC method. FIRAC is an acronym. It stands for these things: facts, issues, rules, application, and conclusion. Now, I'm going to show you many pictures today, but there's only 3 slides I would encourage you to take a picture of, and this is one of them. Because what we're talking about now in this FIRAC analysis is how all lawyers are taught to think in our law schools. Facts are evidence, and we're going to talk about the 5 types of evidence in just a minute. The issues are the 5 defenses to any crime, including all the economic harm that we're about to talk about. But it also includes the violent crime we could talk about too. Rules are the laws. They either come through case law, court-made law, and that's called precedent, or they are the laws that legislators pass in order to have the statutes that we enforce. And many prosecutors are unfamiliar with some of the financial laws that are actually at play because they're not used to trying these cases. And so one of your jobs might be to actually educate these prosecutors about what laws might apply, particularly if there's jurisdictional issues involved. What we have to do next is apply the facts to the laws that we have in order to reach a conclusion. And that's what we mean by the application or the analysis part of how we're thinking. But the conclusion is, do we even charge this case? The conclusion at a trial is whether or not this jury has convicted by rendering a verdict, and we've overcome proof beyond a reasonable doubt. And a conclusion for a judge is when they're sentencing, either to probation to give back some restitution to victims who are harmed, or even to put those defendants in prison cells, like we're going to talk about. So this FIRAC analysis is something that you need to have a sense of when you're walking into a room to meet with the prosecutor, who might be the one deciding whether or not they're going to take your case forward. Now, look at this picture. Many of you right now in the United Arab Emirates, or wherever you might be throughout the Middle East, are used to seeing dry places. You're used to seeing things that are beautiful, like what you see on the left-hand side. What you're not used to seeing is rain. You're not used to seeing water in these deserts. Well, it is the same thing with the victims of many of these fraud cases and extortions and obtaining property by false pretenses and embezzlements that we could talk about. In their setting, crime is very rare. It is only a theoretical threat until it happens to them. And when it does, they want justice, but some of them, again, are too embarrassed to even report. These victims are as surprised to see this crime as you might be when you're suddenly standing in this desert and see rain. Now, what if I had to prove to you right now that it's raining outside? How would we do that? Well, talking about the burden of proof, overcoming proof beyond a reasonable doubt, we again have to understand the language of prosecutors, because those facts that we first search for when we're sitting down with you and you're there to tell us a story, many people are raised to think like a reporter, and they think of what we say in America are the 5 W's, the who, what, where, when, and why of a case. But actually, that's not what I would ask you to focus on. Instead, focus on the 5 types of evidence, because these 5 types of evidence are what we're actually going to put in a courtroom, not what's hearsay, not what's inadmissible, but what we can actually use at the end of the day to say this person did the crimes that we might be charging and then ultimately taking to verdict. So let's talk about what those 5 types of evidence are. There's direct evidence, there's circumstantial evidence, physical evidence, testimonial evidence, and other crimes evidence. Now, this is yet another one of those slides where I would encourage you to take a picture. In other words, these are the 5 things that we look at when first looking in the FIRAC analysis of the 5 types of evidence that we can rely on to prove these cases beyond a reasonable doubt. Now, direct evidence is where you actually look at something and come in as a witness and testify about it. An eyewitness, for instance. They can look out a window and say, it's raining outside, and they can take a witness stand, be subject to cross-examination, put under oath, subject to the laws of perjury, and we can base their whole case on the testimony of a witness that has direct firsthand knowledge of whether it's raining outside right now. But another thing we could do is we could rely on circumstantial evidence. Circumstantial evidence is a group of circumstances that point to something having occurred, but no one's observed it directly. So instead of a witness being able to tell you that they've looked out the window and that it in fact is raining even in the desert, what we would do with circumstantial evidence is bring in maybe physical evidence, a wet umbrella, a person in a raincoat that is soaking wet. And without even opening their mouth, we could say beyond a reasonable doubt that it's logical that it's raining outside, because in someone's experience, using their common sense, they could say that that is physical evidence, circumstantial evidence to suggest that that fact is occurring, even if it's not directly observable. And in fact, that's what prosecutors rely on all the time. Think about DNA and fingerprints in these violent crime cases. It's the same thing when we're talking about these complex financial cases. Follow the money. That will tell you the story. And so many times it's a digital footprint that's left by one of these defendants. And you are the one who is now interpreting this data for us. And we are catching them because of this physical evidence, because of this circumstantial evidence. And finally, there's other crimes evidence. Other crimes evidence is when someone's life is looked more at full. And now we're not only looking at the case before us, but maybe a whole pattern of activity. In Latin, they call that the modus operandi, or MO. We're talking about someone who is methodical, maybe who is scamming many different people, or taking advantage of the same victim over a long period of time. In these cases, what we're doing is we're taking evidence from one case and putting it into another one to show that there's no accident here, that there is actually premeditation and deliberation in the case of a violent crime, or in the case of a financial crime, that there is someone who is slowly and very methodically taking advantage of someone frequently who has entrusted great care to them. Because many of the financial harms that we could talk about involve using kindness and turning it into weakness, and then taking advantage of that kindness over sometimes a period of years. Or they might be reaching across jurisdictional boundaries where they're unknown and doing the same thing over and over again to a series of victims. Now, to show you these points graphically, again, the two ways that we can prove a case, direct and circumstantial, involve either calling witnesses to a stand, putting them under oath, and the jury can believe all, part, or none of what they have to say. That's direct eyewitness evidence. That's the testimony of witnesses. And many of you have been called into a courtroom and been put on that stand and know what it means to have your integrity on trial itself, and that your reputation has to precede you, and that your word is your bond, and that you should meet with the prosecutors ahead of time to make sure that you're going to take the complex and make it simple and understandable to maybe a whole jury listening that might have collectively an 8th grade education, not the college education or graduate degrees that you might have. And then again, the second way we can prove that it's raining outside is through this circumstantial evidence or physical evidence, the wet rain jacket, the umbrella, the person who's soaking wet. And again, you're taking physical evidence, very frequently documents, you're creating charts, you're showing videos, you're, in other words, taking things that we can touch, we can see, we can hear, and we're putting it into that courtroom. That's what we mean by direct and circumstantial, testimonial, and physical. And this other crimes evidence is often interpreted, just like the physical evidence and circumstantial, by an expert. Again, if we were trying to show it's raining outside, maybe we would call a weatherman. They could get onto the radar, for instance, and say there's clouds on the horizon and interpret something called Doppler. Or they could look at a forecast and tell the jury and judge whether it's rained before. Many of you have had that experience of being qualified as an expert witness. In other words, you have a little bit more knowledge than the average person, or a whole lot of degrees that give you the right to interpret complex things. And what you're doing is you are showing very frequently a pattern of activity involving this person that you're urging me to charge, and this jury to convict, and this judge to sentence. So that is your job as an expert witness. And if you remember those 5 types of evidence, direct, circumstantial, testimonial, physical, and other crimes evidence, if you talk to your prosecutor about these things at the very earliest stage, we can start thinking alike and speaking alike, and you have a much greater likelihood of getting justice in that case. Now, the second part of the FIRAC analysis is the I, and that's the issues. And what we're really talking about there are what I call the 5 defenses. The 5 defenses to any crime are what I'm about to talk about. Now, when you think of crimes, you probably think of embezzlement, fraud, extortion, false pretenses, scams of every variety. All of those cases have defenses, where a defendant who in America has the right to remain silent and the right to have an attorney appointed to represent them once they're charged and might not ever say a thing. Well, what we're doing in this analysis now, sometimes before we've ever even made a charging decision, is we're sitting down with you, the investigator who's taking a complex case and trying to explain it to us. And we're determining, what would the bad person say if they opened their mouth? In other words, what would the likely defense to this case be? Again, whether we're talking about one of these financial cases we just mentioned, or drug trafficking, or a crime of violence, or any other type of case we could talk about, there's only 5 ways to defend any case. We're going to talk about them now, and then I'm going to show you a series of cases that I've personally handled through the years to show you how those 5 defenses come up in a courtroom, and how we can overcome them through good investigative work. Here's the 5 defenses. Some other dude did it, what we call the Saudi defense, the classic whodunit. I didn't do it, underlining the word it. In other words, saying that they might have been guilty of something, but they're most likely overcharged. They're guilty of not, for instance, breaking and entering, but only larceny. They're not guilty of extortion. They might be guilty of an obscene phone call. They might not be guilty of robbery, but only taking things when no one was under threat of force. Not guilty of murder, but only guilty of manslaughter. What they're saying is the label doesn't fit. And we'll get to those cases in just a minute. Next, they might say, of course I did it. Where they're not denying the crime, they're saying they were legally justified. Again, just to show you in the violent crime context, when someone shoots someone else, frequently they say, yes, I shot that person. They tried to shoot me first. That's self-defense. Or in a rape case, yes, you're going to find my DNA. That's because it was a consensual encounter. In other words, what they're saying is, you're going to find that I did the act you're talking about, but it's not illegal. I was legally justified. And that's frequently what a sophisticated defendant will say when you're bringing these cases into a courtroom to show that they embezzled, for instance. The next type of defense is, the devil made me do it. You know, we have to prove the criminal mind of a defendant in every case. In Latin, we call it the mens rea, or guilty mind. Well, frequently a defendant will say, I wasn't in my right mind at the time. In the classic case, we're talking about insanity, where someone truly doesn't know the difference between right and wrong. Much more common is someone who is under some form of chemical impairment at the time. Maybe someone who has a bad drug addiction, or was grossly impaired with alcohol at the time of the offense. What they're saying is, I'm not guilty of the specific intent offense because I was not in my right mind at the time I did it. And I bet you've had many cases where a person was slowly stealing from people around them, probably because of a chemical impairment, a drug addiction. And finally, here's probably my favorite defense. Maybe you did it. That's where the defendant is saying that the only reason you have a case is because you created a crime and talked me into doing it. In other words, I've been entrapped. And we see many of those cases arise when we're trying to catch people on film doing the thing that we've alleged that they would do again, or make a pretext call and find them talking on a recorded line. Or they might say, you know, because of your sloppy work, because the investigators did not collect the dots, we can now no longer connect the dots. Your burden of proof fails because the prosecutors and police didn't do a good job. In other words, the defendant in this defense is putting the very process on trial itself. There's an old adage that if you don't have the facts, you pound the law. If you don't have the law, you pound the facts. And if you don't have either, you pound the police and the prosecutors. In other words, you and I are in this together. We're very likely going to have to make sure that we've got all of our I's dotted and our T's crossed, as we say in the United States, before we can go into that courtroom together. So let's talk about how we can get justice in these cases. Let's first talk about a woman who I prosecuted about a decade ago, who worked at this beautiful restaurant right along the Cape Fear River. It's called Elijah's. This restaurant, and there were several next door, like the Pilot House and others, they were owned by the same very wealthy family. Beverly Brown was hired to be their accountant for their privately held firm. She was a college graduate. She was a new mother. And over the course of several months, the books weren't adding up. The family started to realize that their profits weren't as much as they used to be historically. And so they hired someone like you, an internal auditor, to do a forensic accounting. And what that person realized was that over the last 9 months, this woman had slowly taken over $250,000 from this restaurant you're seeing in this picture. Now, when she was confronted, of course, she was a very savvy defendant. She was well educated. She had access to the same books, and she tried to cover her tracks very well. But the evidence, and remember, think about the 5 types of evidence. that we were ultimately able to gather through great investigative work by a forensic accountant was that she had opened up another bank account at another bank, and she was putting that money into that account. Her initial defense was some other dude did it. That is, that someone else who also had access to the cash registers was taking the money. But when she was confronted with that evidence, the defense changed. And very frequently, those 5 defenses, a defendant will raise more than one in the course of an investigation or trial. Her defense changed to, the devil made me do it. You see, Beverly became addicted to pain pills soon after her child was born, and she needed a C-section in order to have that child. And through complications, she required pain medication for several weeks. And when those pills ran out, that addiction turned to illegal drugs. And so what she was claiming is, have mercy on me. You see, I'm a good person who has a bad problem. And so she wasn't using this defense to say she wasn't in her right mind. Instead, she was using this defense to try and get leniency from the court. Well, the judge who ultimately sentenced Beverly Brown didn't have much leniency. In fact, even as a mother of a 2-year-old child at the time of this trial, she was sentenced to prison for over 4 years. And she was also, of course, ordered to pay back that $250,000 in restitution to the family who owns Elijah's restaurant. And it's because of good forensic accounting that we even caught her. Next, let's talk about obtaining property by false pretense. And I want to introduce you to Oliver Wells. He's a general contractor who built luxury homes at the beaches, including the ones you're looking at in this picture. Now, we have hurricanes in Wilmington, North Carolina, which means beach houses can blow down if they're not constructed correctly. And Oliver Wells claimed to be the man of steel, which is a play on words for Superman, because that's what Superman is called also. But he said he's the man of steel because he was putting steel beams into these homes that could withstand much harsher winds than wood alone or even brick. And so many people said, if he's going to use those type of expensive materials, we should have to pay more. And we're going to hire him to build our dream home. Well, banks, of course, require that when they're giving out money throughout the course of construction, they're going to send inspectors to the sites of these places to make sure that the materials are there before the general contractor, Oliver Wells, was allowed to draw money out on that construction loan. And so what he would do is he would take these expensive steel beams to a construction site. An inspector from the bank would come by, see the beams, which were very expensive, and give Oliver Wells money for those beams that were presumably then going to go into these homes. But what this man would do next is he would take this same set of beams down the beach to another home that was under construction, call up the next bank and say, here's your materials, here's the expensive beams, I need money for that. And these steel beams were never getting into these homes, and they weren't constructed nearly as well as he was claiming for all these people who were paying him exorbitant amounts of money to build these homes. Well, his defense, when ultimately caught, was, listen, I've only not put in steel beams. I didn't do it, meaning I'm overcharged here, because what you're now claiming is that I've taken over $100,000 from people, which is more expensive than a typical scam involving any one victim. And because we were able to aggregate this money of $10,000 here, $12,000 at a next site, and have more than 10 victims, we could add all of that victimization up together to get more than $100,000 that he has taken, which gets us over the threshold of what's called a Class C felony, which means it's much more seriously punished under our laws. Actually, as serious as bank robbery if he had had a gun and a ski mask on at the time. And so what we were able to do by showing other crimes and by showing this pattern of conduct, by having an expert basically interpret all of these cases for us, was that Oliver Wells was one of the worst kinds of defendants. He was taking a little bit here and there from many different people and using this scam in the hopes that no one person would even realize what was in the walls of their own home. So we were able to convict him because we had an accountant, maybe like you, who was able to add up all the money from as many victims to get us over that $100,000 threshold. And we sent Oliver Wells to prison. And his victims, of course, were repaid with the money that he had stolen from them. Speaking of I didn't do it defense, here's another one that happened just earlier this year in my district. Meet Otis Lee Howell. Now, he's an unusual individual. He lives in the rural state of Alabama, somewhere in the middle of the United States. I've never met this man prior to this case. Here's what he had been doing for 25 years. Otis Lee Howell was calling up women who he had researched on the internet. He would find a Facebook page about them, usually a real estate agent, by the way, a female who had a family, usually with a teenage daughter. And what Otis Lee Howell would do is find out their contact information and then call these women who he had never met, never even been in the same state with. And it would go something like this. He would say, "Ma'am, I have your daughter. She's kidnapped and she's in my house right now, tied up. Don't call the police and do not hang up. If you don't do exactly what I'm going to say, I will harm, maybe even kill your daughter. But I'm going to let you take on her pain for me." And then what he would make them do is he would make them talk to him in a sexual manner. In other words, he was doing what seemed to be an obscene phone call. But what he was actually doing was he was stealing something. He was taking away the dignity and respect that these women had. And in return, he was receiving sexual gratification. Now, this might not be a typical scam involving money that's being robbed, but clearly we have extortion because under the threat of violence, he is taking something of value from these women. Now, when I first heard about this case, of course, like you, I was outraged. I'm like, where is this defendant? And it turned out he was several states away. And when these investigators looked into him, we realized that there were many victims all over the United States who he had been doing this to for more than 25 years. And in all those other places, when prosecutors like me heard about them, they said, well, it's only an obscene phone call. It would cost a lot to extradite him and bring him into our jurisdiction. We're not going to bother. Well, we had other crimes evidence. We had 5 different women in my jurisdiction alone and several others around the United States. And we said, no, the road should end for Mr. Howell right here in Wilmington, even though he's never set foot here. And so we had agents with the Federal Bureau of Investigation go make an arrest, bring him back here, and put him in a courtroom. We convicted Otis Lee Howell earlier this year, and he's in a prison cell today. And it all started with an investigator, maybe like some of you listening, sitting down with me and some of my prosecutors to make us understand the much larger picture of this individual and why we should all care. Next, there's something that happens quite frequently in states of emergency, and that's price gouging. Many of us are familiar, again, in this region with hurricanes. Maybe in your part of the world, there's a different thing that will come about, an earthquake or a tsunami or some event, maybe a sandstorm. Whatever it is that might occur, when there is a state of emergency, there's desperation that follows. Many people need to build their homes back up, or they need to clean their yards of debris. Everyone needs to find gasoline for their cars, and a lot of times gas stations have now been shredded and ripped to the ground. And what happens in the wake of these tragedies is that there are people who come into town to offer to do yard work or build those homes back up, or even gas stations themselves that are permanent fixtures there. And what they're all doing is suddenly raising their prices. And they're doing that because they can. Now, this defense is the of course I did it. In other words, what these defendants are saying, whether they're corporate defendants like gas stations or they're yardmen that come in or people who build homes, is they're saying this is supply and demand, and there's more people who need our services now. And so what was a certain price beforehand is going to be greatly elevated now that we're in this state of emergency. Well, that's not legal. That's actually called price gouging. And what we sometimes need an expert like you for is to show what the market was bearing before these terrible tragedies and after. And sometimes there's far-reaching conspiracies involving people within the same agency or same type of career who are setting prices in violation of things like the Sherman Antitrust Act here in America, where what they're doing is they're raising prices above what they should because they have what is in essence a monopoly for victimized people. And for any one person, it might only be a few cents on a gallon of gas or a few $100s more for their yard work. But when you spread out that economic harm to everyone, for instance, 300,000 people in my area after a hurricane, we're talking about millions and millions of dollars. So of course we should be taking those cases seriously. And we've had to prosecute many of those cases through the years in my district. And then there's public corruption. Meet Billy Williams. Now, Billy Williams was someone who we called the Godfather because he was in charge of regulating the sale of alcohol throughout New Hanover County. Now, how it works in the United States in the South where I live is that in order to sell alcohol, not beer or wine, but alcohol like bourbon and vodka and gin, is that they can only be sold in these stores. And a state employee, in this case, Billy Williams, is in charge of regulating who can go in there and buy it and when they can get access to that alcohol. Obviously, that's a very powerful position. And because you can only buy it at an ABC store, we need to build several stores throughout our community so that people have access to that. Billy Williams got to decide where those stores were built and how many of them were built. And needless to say, there was a great cry for builders to say, we want those contracts, and they engaged in a public bidding to try and get the right to build those stores. Well, a contractor was able to get those first couple of stores built, and that's when Billy Williams came to him and said, if you want to continue to build these ABC stores, I need you to do something for me. I need you to add a nice addition onto my personal home. You see that in the bottom right corner. Now, this general contractor, of course, wanted to keep making plenty of public money by building these ABC stores. He, of course, didn't want to write off all the expenses that it would take to build Billy Williams his dream home. So what they conspired to do together is for Billy Williams to just add more materials, more cost to these ABC stores, and the general contractor would simply take those supplies and put it into Billy Williams' kitchen or living room or den or garage. So they were kind of in it together. Billy Williams was caught when he started giving himself large raises in addition to building his own home with the proceeds from these ABC stores. And how we ultimately caught him was a forensic accountant came to us and said, you know, we have a general contractor who is willing to testify against him about this far-ranging conspiracy that's lasted years. Billy Williams, in his defense, said, of course I hired this great general contractor to build my home. He's done such a good job on all my stores. And it was only taking that testimonial evidence, that direct evidence of someone with inside knowledge, and the pressure that you applied by showing these forensic accountings that showed the back and forth money between the two, that we were ultimately able to get back so much of the public money that the Godfather had stolen. This was one of the biggest cases we had in our region. And it just showed the importance of maintaining the public trust and following the money. Sometimes the biggest thieves are entrusted to take care of everybody else in government. And then there's this woman, Amy Stewart. Her mother was a great lady. Her mother was actually part of the greatest generation, someone who was a widow of a war veteran from World War II. And because of that status, Amy's mother received a large check each month from the United States Treasury, pension. Well, Amy Stewart and her children relied a lot on that money. Her mom lived with her for their everyday needs. Well, then the mother passed away. But Amy Stewart didn't report that. Instead, she kept her mother in that bedroom. As the body began to decompose over the next several weeks, she, of course, covered the body with blankets and then sprayed disinfectant, put detergent and deodorant all throughout the room to mask the smell, closed the door, and then through the next several weeks continued to receive these Social Security checks and other pensions. In other words, still pretending that her mother was alive. Well, her son, after several weeks, told a friend who then reported it to the authorities, and the scam was up. When she was ultimately arrested, her defense was, the devil made me do it. I was so distraught by losing my mother that I went into an almost temporary insanity and was overcome with grief. Well, it was forensic accounting that showed exactly where she spent that money and what she did with it. And needless to say, what took over was not grief, but greed. And she was ultimately convicted of all these crimes because of your good work. It's important, again, sometimes to just follow the money. And finally, we see as a common scam, things that happen on the internet and over the phone. Just about everyone around the globe has received an email from a Nigerian prince that if you just simply send me some money, you will be able to tap into my vast fortune. And many people receive a phone call like this elderly woman that you're seeing in this picture. It goes something like this. A caller pretends to be a grandchild of a senior citizen and says, "Grandma, I've just been arrested. Please don't tell Mom." Mom, of course, is the daughter of the woman who's answered the phone. "See, I need bail money. I'm in jail. And if I don't get that, there's some bad people in here who can hurt me. Please send money. Let me give you the account." And so this grandmother, not wanting, of course, to do anything other than help a grandchild, sends that money and doesn't even tell her own family because she wants to maintain good relations with the great grandchild that she loves. Well, of course, that's a scam. And we see it so many times. These are the vulnerable victims, the ones that have such shame, who can't believe they've been duped. What do we do for them? Well, maybe you've had the experience of having a friend or family member who's fallen prey to this scam or had it reported to you, and people say, well, what can we do? Sometimes we can track that number and actually figure out who made that call. And maybe you would like to set up what's called a pretext phone call, where you're now saying, if we get on the phone with this person who has scammed potentially so many people in different places, we can catch them in the act. Well, here's the danger. If you don't meet with your prosecutor ahead of time, it's very possible that the things you say and the way you say them can be interpreted later in a courtroom as entrapment. In other words, that scammer will say, the only reason you caught me on that recorded call is because you dangled something in front of me that I would have never have taken the bait on, but for your criminal conduct. In other words, you did it. You're the reason that I am on this recorded call talking to this woman in this certain way. So I would just caution you that if you're in the part of an investigation where you still might be creating evidence, not just finding it, please meet with your prosecutor ahead of time so that we can go over the legal pitfalls of what can be done and what cannot be done in order to get that critical evidence in front of a court one day. Now, what we've been talking about are some things that are weaknesses. Many of us are going to be watching the Olympics in Tokyo in the next few months. And one of my favorite sports to watch is judo. Because in judo, you take a weakness and make it a strength. You use the opponent's weight against them. And that's frequently what we are doing in a criminal courtroom. We've talked about the 4 weaknesses in bringing financial cases to your prosecutor. When you're trying to speak the same language as us, let's turn these weaknesses into strengths. What do I mean? Well, let's talk first about the victims. Remember, I said that many of them are vulnerable and that they have shame and might be really embarrassed, particularly some of our most sophisticated corporate clients who pride themselves on being bright and can't believe that they've lost maybe great investments for people who really trust and look up to them. Well, when you're meeting with the prosecutor, remind them that they probably do what they do for a living because they care about innocent people who have been harmed. And all the victims I've just mentioned were completely innocent. They might have fallen for things that other people might not have, but they were completely innocent and vulnerable. And that's why we do what we do for a living. So take that strength into a courtroom with you. And don't forget to speak the language of prosecutors when you're talking to them. Next, yes, these cases are complex and that might scare people initially, but most prosecutors love a great challenge. We want to take something that's difficult and make it more simple for a jury. We want to look like we're smart too. And so show us why it is that this thing happened and how you as an expert might be able to help us interpret what we're looking at. And you're going to find that you're speaking our language. Next, even though many of these cases occur outside of our jurisdictions, we want to get justice at home for the people who are harmed. Think again back to that Otis Lee Howell case, where there might have been great harm done over several decades in other places in my country. But we decided to bring him here because we realized that the road could stop with us if we did our job. And many prosecutors know we shouldn't use get out of town pleas or get people on the road simply to perpetrate their crimes in other places. No, if we're really doing our job, we want to make sure that regardless of where these crimes occurred, that we're getting justice in our hometowns. And finally, and maybe perhaps most importantly, I have seen through the course of these last 22 years that I've been a prosecutor, more harm done with someone using a computer or a phone than with a gun and a ski mask. Very frequently, it is these sophisticated financial crimes, not the armed robberies, that bring about the greatest harm to people. We all know that maybe they don't bleed, maybe there's not somebody who needs hospitalization, but this harm that we're talking about now steals a peace and security that people walk around with every day. It might ruin a nest egg of someone who has spent a year accumulating their wealth. It might be financially ruinous to a business or to even a family. That's why we need to care about these cases. Make the prosecutor you're talking to care also. So in summary, when we talk about speaking the language of prosecutors, it's as easy as 1, 2, 3. Don't forget the FIRAC analysis, F-I-R-A-C, which stands for facts, issues, rules, application, and conclusion. Where we take facts, we spot what the defenses are. We understand the law, maybe from you, and then go and look it up and research it. We apply that law to the facts to come up with whether we should charge, how we are going to work together to convict, and maybe what the ultimate sentence should be in that case. And then let's not forget about the 5 types of evidence, the facts, direct and circumstantial, testimonial and physical, and yes, other crimes evidence, which might not just show the modus operandi, the planning, the preparation, maybe even the premeditation and deliberation, but might even go to the very identity of the perpetrator, because what they're doing is so bizarre, so unique, that it might even be elevated to what we call a signature crime, to truly catch somebody, not through DNA or fingerprints, but through showing that they've done it so many places that it has to be them. And finally, don't forget about these 5 defenses, because these are the issues that very frequently scare away prosecutors, saying this is going to be too hard to prove beyond a reasonable doubt. Know these 5 defenses. Some other dude did it. I didn't do it. Of course I did it. The devil made me do it. Or maybe you did it. When you see all of those case studies, you'll become more conversant with this language. You know, I've had the great privilege now of being the elected district attorney since 2004. And this past year, I worked really hard during the pandemic to put all of that journey into writing. And I'm very privileged to tell you that earlier this year, a publishing house out of San Diego, California, published a book that I've written. It's called Crime and Community in the Cape Fear, a prosecutor's guide to a healthier hometown. There are more than 25 case studies, like the 8 cases I just showed you this morning, that we talk about the different types of evidence. We talk about the different types of defenses. We use this FIRAC method over and over again, so that by the time an internal auditor like you, an expert witness like you, gets finished with this book, you will know how to speak the language of prosecutors. And it's my hope that in taking this journey with me, you will be much more effective in your hometown also in taking these cases into a courtroom and ultimately getting justice. I've also created a video series that tracks this book, and you can go to benjaminrdavid.com to not only order the book, but watch the more than 12 hours of videos that discuss these cases in greater detail. I hope that we have an opportunity to work together in the future. And I hope that this time next year, when this conference is again in person, we have the benefit of being in the United Arab Emirates together. Thank you so much for your time and attention today. Take care.
Benjamin, thank you very much. More so for those examples and those cases that you highlighted. It was, so as to speak, most entertaining. There are a couple of questions, Benjamin, that did come up. One of them,
I'm happy to answer.
Yeah. One of the questions is, why do we see instances when a lower court punishes, and for the same crime and with the same evidences, the upper court then acquits? So how come it is that two judges see things differently?
That's a great question. The trial court is concerned with making sure that the rules of evidence are followed and that it's ultimately a jury through its verdict that is the judge of the facts. So we have to prove these facts beyond a reasonable doubt in a courtroom. But what a court of appeals looks at, sometimes called a Supreme Court in other jurisdictions, is whether any legal errors have been made by that trial judge, or whether there was not enough evidence to support the charges that this jury ultimately convicted upon. We have great frustration in looking at some of these cases where a defendant will escape in a legal technicality because, in my country, for instance, one of the rules that's enshrined in our Constitution and the Bill of Rights, like freedom from unreasonable searches and seizures, we didn't get a proper search warrant, or they weren't properly Mirandized under the Fifth and Sixth Amendments, the right to remain silent and the right to an attorney, or that there was some legal defense that we violated, like entrapment that I mentioned earlier. So even though a jury has convicted and said there's no doubt that that person is guilty, a judge on appeal is saying, we love the law more than this individual case, and even though this person did it, we are going to uphold the rule of law by saying that because it was violated by well-intended investigators or prosecutors, or misapplied by a trial judge or by a runaway jury, that we're going to reverse this verdict, even though this person is absolutely guilty. That's what happens if we don't speak the language of prosecutors and investigators at the earliest stage. And that's why it's so important to get on the same page early. In this murder case, for instance, that I'm trying now, it would be a lot easier if we could play the defendant's confession, but we were not able to, because that confession that he gave right after arrest was suppressed under the same rules of evidence I'm talking about. And so I would just encourage anyone listening that if they have a case that's really important to them, that they meet with the prosecutors in their hometown at the earliest stage, so that you not only get justice at the trial level, but it stands for all time at the appellate level too.
Thank you. And I think that just partially answers the second question, which I would like you to elaborate a little further more from the auditor's standpoint of view, is when the auditors do come up with evidence, through whatever means, either they've seen red flags or they've done their own investigative work while conducting individual audits, and they compile it in a format which is not in line with the prosecutor's requirements. In your opinion, do such cases fall flat?
Yes, they do. We have a saying in America, I don't know if it translates into Arabic, but we use what's called the KISS principle, K-I-S-S. And that means keep it simple, stupid. And what we're saying is, pretend that the person who is listening to you right now doesn't really understand what you're talking about. How can you make something complex look simple? Do you have some type of visual aid that might assist in this? If you have a lot of data, can you put it into a chart for us? Can you use pictures to help illustrate a point that might take 10,000 words to say? For instance, in the case I'm trying now, I know that many of the people on the jury are going to get lost when we talk about the accelerant that was used was a specific type of gasoline that we caught the defendant purchasing just before the fire. And so what we did is we called an expert witness from the State Bureau of Investigation to show exactly what type of petroleum products were in this debris at the end of the fire. Well, when we actually have to present this in a courtroom, we're showing different graphs of the different types of petroleum out there. Kerosene, diesel, unleaded gasoline, starter fluid, and how these different peaks and valleys in the type of graphs from a gas chronometer would be different depending on what substance we're talking about. So now the jury is not just hearing very technical terms, but they're seeing, almost like you would with DNA, that what they have tested matches up to the substance that the defendant is seen on video purchasing. So I would encourage you to do the exact same thing when you're using financial data that might be in several boxes. Is there some way you can visually present it to your prosecutor? Is there some way you can put it into a usable format where in 10 seconds rather than in 10 hours, you could tell even somebody who doesn't have a financial degree why it is that the person we're talking about is absolutely guilty of a terrible crime? In other words, try to keep it simple for us, because many of us are not as bright as we pretend to be.
Well, I think that's just about time we have, Benjamin, for questions. I'm going to leave it with Samia to conclude the day. Thank you very much.
Thank you so much for this kind invitation, and I hope it's helped today, and I look forward to hopefully being with you next year.
We hope so that you will be with us next time, for sure, inshallah. Thank you very much, Mr. Ben David, for explaining how to understand the language of prosecutors and providing real-life experiences. Thank you very much. Looking forward to meeting up with you here in Dubai in real conferences. Thank you very much.
Thank you.
With this session, ladies and gentlemen, we come to the closing of day one. Thank you for attending. Looking forward to welcoming you to the conference tomorrow. Enjoy your evening and see you tomorrow. Please.